Good evening, everyone. I warmly welcome you all to today's special class by LiveLaw Academy. Today's session is on jurisdiction of the criminal courts, inquiry and trial part 3. If you've missed the first two parts, it's there in the YouTube channel. You can go and check that out. Before we begin, it's both my honor and privilege to introduce the guiding force behind this session, Justice V. Ramkumar, sir, our patron and chief mentor at LiveLaw Academy. Justice Ramkumar, sir, is a distinguished former judge of the High Court of Kerala. Sir began his legal journey with an LLB from Government Law College, Mumbai, and enrolled as an advocate in 1979. In 1987, Sir was directly recruited as a district and sessions judge. Sir later served as a law secretary to the government of Kerala and was elevated as a permanent judge of the Kerala High Court in 2004, a position Sir held with great distinction until Sir's retirement in 2012. Over the years, Sir has also served as the chairman of the advisory board under Kerala Anti-Social Activities Prevention Act. Sir is a much sought after speaker, regularly invited by judicial academies, law universities, and the Bar Council to address judicial officers, prosecutors, and students. Sir's contribution to legal literature includes acclaimed books like Law of Prevention of Corruption, Tendering Pardon to an Accomplice, and Magisterial Trials, Law and Procedure. Sir's unique Q&A style legal articles on live law have helped decode tough concepts for students and practitioners alike. And now, without further ado, let's all welcome Justice Ramkumar, sir. Sir.
Thank you. Good evening, friends. We are on the jurisdiction of criminal courts in inquiries and trials. We saw what is an inquiry. When does it begin? When does it end? We saw what is a trial. When does the trial really begins? And when does it end, etc. Now, we also considered the other day the first section in chapter 13 CRPC corresponding to chapter 14 BNSS, namely section 177 CRPC corresponding to section 197 BNSS, which says that the jurisdiction, every offense shall ordinarily be tried within the and tried and inquired into and tried by a court within whose local jurisdiction the offense was committed. That is what we call territorial jurisdiction. We saw that it is capable of being waived if an accused does not raise any objection regarding the territorial jurisdiction, because going by the rule under section 177 CRPC, every offense shall be inquired into and tried by the court within whose local jurisdiction the offense was committed. We have seen section 156(1) CRPC, that is corresponding to that 173 BNSS, wherein it is said that the jurisdiction of the police station and the magistrate are coextensive. Therefore, if the offense has taken place within the local jurisdiction of a particular police station, there will be a magistrate who has got local jurisdiction with regard to that place. And it is that magistrate who has to try the offense under section 177 CRPC corresponding to section 197 BNS. Now, that is a matter which can be waived by the accused. If he does not raise the lack of territorial jurisdiction of the court at the earliest point of time, then he cannot raise it subsequently at the fag end of the trial. He will not be heard to say that, no, this I omitted to raise that point. Now this court does not have territorial jurisdiction. Territorial jurisdiction is in some other magistrate. No, he will not be heard to say that. This is I told you that this is something analogous to the civil law also. Under section 21 of the Civil Procedure Code 1908 also, if the lack of territorial jurisdiction has not been raised at the earliest point of time, then the party will be precluded from raising it at the fag end of the trial. Similar position here also. Now we come to the next section, section 178 CRPC corresponding to section 198 of BNSS. Kindly read section 198 BNSS.
So, section 198 of BNSS.
Yes.
A. Place of inquiry or trial. A. When it is uncertain in which of several local areas an offence was committed, or where
An
or
offence is
B, where an offence is committed partly in one local area and partly in another, or where an offence is a continuing one and continues to be committed in more local areas than one, or D, where it consists of several acts done in different local areas, it may be inquired into or tried by a court having jurisdiction over any of such local areas.
See, what a wide latitude has been given by the lawmaker with regard to the jurisdiction of a criminal court. In all the four situations, a court can try the offence, and it may not be possible to raise any lack of jurisdiction. Now, let us examine a few questions on this section so that the matter will be clear to you. Question number 1, please read.
Question number 1. What is the meaning of the expression local area in the context of jurisdiction?
We find the expression local area in the section. So what is the meaning of that expression? The said expression means the territory within which the court or the magistrate may exercise all or any of its powers under the CRPC or BNSS, and such local area may comprise of the whole of the state or any part of the state, as the state government may by notification specify. It is left to the state government to specify the local area of every court. In case an offence has been committed in two local areas, then as per section 178 CRPC corresponding to section 198 BNSS, which has been just now read over to you, the offence can be tried by any of the courts having jurisdiction over such local areas. That is what the section says, and it has been judicially noticed also in Vishwanath Gupta versus State of Uttaranchal, 2007, volume 11 SEC 633, corresponding to 2007 Criminal Law Journal 2296. The judges are A.K. Mathur and Lokeshwar Singh Panta. Now, please read question number 2.
Question number 2, sir. What is a continuing offence for the purpose of section 178 CRPC, that is section 198 BNSS?
Yes, we saw the expression continuing offence being used in this section. What does it mean? Now, continuing offence means a type of crime which is committed over a span of time. This was what the Supreme Court observed in Kokak Patel Volkart Limited versus Bandaya Guru Siddhaya Hiremat 1991, volume 2 SEC 141. The author of the judgment is Justice K.N. Saikia. Likewise, traveling without a passport is a continuing offence. Likewise, traveling without a ticket is a continuing offence. The offence is committed the moment the ticket is the journey has been commenced without a ticket, and it goes on until you are caught. Until then, it is a continuing offence. Any time he can be caught and a case registered against him. This was held by Abdul Samad versus State of UP, Allahabad High Court, AIR 1965, Allahabad 158. AIR 1965, Allahabad 158. The judge is Gyanendra Kumar, Justice Gyanendra Kumar. Then come to question number 3.
Question number 3, sir. Will maltreatment and humiliation by the husband and in-laws on various occasions amount to an offence falling under section 178C CRPC, that is section 198C BNSS?
Yes. See, what is 178C? 198C, where an offence is a continuing offence, continuing and continues to be committed in more local areas than one. That is clause C of section 198. Now, here it is the wife is subjected to maltreatment and humiliation by the husband and his relatives on various occasions, whether it is a continuing offense falling under Clause C of Section 178 of CRPC, corresponding to Section 198 of BNSS, is the question. Yes, it amounts to a continuing offense within the meaning of the said provision. Sujata Mukherjee versus Prashant Kumar Mukherjee, AIR 1997, Supreme Court 2465, corresponding to 1997, Volume 5, SEC, page 30. Judges are Justice G.N. Ray and Justice G.T. Nanavati. Now, question number 4.
Question number 4, sir. Can a magistrate or court try a case in which part of the offense falling under Section 420 and 406 IPC, that is Sections 318 and 316 BNS, falls within the
BSA.
So
BSA. Corresponding to IPC. BSA. Did not.
Falls within the jurisdiction of the said magistrate or court.
Yes, we have already seen the section. Section itself is very clear. Yes, if part of the offense falling under Section 420 or 406 IPC falls within the jurisdiction of the said magistrate, it is enough that a part of the offense is within the territorial limits of a magistrate and another part is in the territorial jurisdiction of yet another magistrate. It is enough that a part alone is there within the local area of a particular magistrate. That magistrate can try the offense. That is the question, and the answer has been answered in the affirmative by the Supreme Court. Asit Bhattacharjee versus Hanuman Prasad Ojha, AIR 2007, Supreme Court 1925, corresponding to 2007, Volume 5, SEC 786. Judges are Justice S.B. Sinha, the author, and Justice C.K. Thakur. Yes, question number 5.
Question number 5, sir. An accused facing a charge for an offense punishable under Section 13(1)(e) of the Prevention of Corruption Act 1988, prior to amending Act 16 of 2018, having properties in 3 districts. Supposing there are special courts in each of those districts, which special court can try the offense?
See, what is the offense under Section 13(1)(e) of the Prevention of Corruption Act prior to the 2018 amendment? It has undergone an amendment in 2018. Before that, 13(1)(e) said acquiring disproportionate asset within or assets beyond the known sources of income of a public servant. He is committing an offense under Section 13(1)(e). Now, in a given case, a particular person has got properties within the local limits of 3 special courts. 3 districts where there are special courts. So the question is, which special court can try the offense? Any of the special courts can try the offense. And if more than one special court has taken cognizance of the offense, rather, if supposing 2 special courts have taken cognizance of the offense, then the remedy is under Section 186 of CRPC, corresponding to Section 206 of BNSS, where the High Court can specify which court shall continue the trial, and the other court will not be able to continue the trial, because there cannot be 2 trials by 2 different courts, which may result in conflicting verdicts. So each of those courts can try the offense, since part of the properties, in fact, the accused have properties within the limits of 3 special courts. The Supreme Court has observed that any of those special courts can try the offense. V.K. Puri versus CBI, 2007, Volume 6, SEC, page 91, corresponding to 2007, Criminal Law Journal 2929. Justice S.B. Sinha is the author of the judgment, and other judge is Markandeya Kadju. Question number 6.
Question number 6. Does a court, through the local limits of which the smuggled goods were carried, have jurisdiction to try the offence?
Smuggled goods, smuggling itself is an illegal act. Smuggled goods were carried through the local area of a particular court. Of course, they were not taken within and deposited within the local area. Just carried through the local area of a particular court. Question is whether that court can try the offence. Answer is yes. In case the holding of the trial in such a court is likely to cause any undue inconvenience or prejudice to the accused, he can move the appropriate forum for transfer of the case. Otherwise, nothing wrong in that court within whose local area the smuggled goods were carried, trying the offence. You may see Harbans Lal versus State of Haryana, AIR 1999, Supreme Court 326, corresponding to 1998, Volume 8, SCC 319. Judges are G.T. Nanavati, the author, and Justice S. Rajendra Babu. Yes, question number 7.
Question number 7, sir. Does a magistrate, within whose limits a part of the cause of action arose, having jurisdiction to try an offence punishable under Section 420, read with Section 120B of IPC, that is Section 318, read with Section 61(1) BSC?
The answer can be in the affirmative. See Clause B of Section 198 BNSS, where an offence is committed partly in one local area and partly in another, squarely falls under Clause B, clause of Section 198. Answer is yes. Rajiv Modi versus Sanjay Jain, 2009, 13 SCC 241, Tarun Chatterjee and H.L. Datu being the author. But where it is uncertain as to which of the several local areas where the offence was committed or where several acts were done in different local areas, the offence can be inquired into or tried by a court having jurisdiction over any such local area. Satwinder Kaur versus State Government of NCT of Delhi, AR 1999, Supreme Court 3596, AR 1999, Supreme Court 3596, Justice K.T. Thomas and M.B. Shah, Justice M.B. Shah being the author of the verdict. Question number 8.
Question number 8. Matrimonial home of the complainant wife at Jabalpur, MP. Allegations in complaint is ill treatment of the wife and demand of dowry by the husband and in-laws, and she had to leave the matrimonial home and start living with her parents at Datia, Madhya Pradesh. Can the magistrate court at Datia try the offence?
From Jabalpur to Datia, she was forced to leave the matrimonial home at Jabalpur and forced to go to Datia. Now the question is whether the magistrate court at Datia can try the offence of ill treatment of the wife and demand of dowry. Because all the offences were committed while she was in the matrimonial home. She was forced to leave the matrimonial home from Jabalpur and she went over to Datia. Can the magistrate court at Datia try the offence? Cannot, because the offence took place within the matrimonial home. So the local magistrate at Jabalpur alone can take cognizance of the offence and try the offence. The answer is no. Since the offence is not a continuing offence, mind you, offence is not a continuing offence. It took place and concluded in the matrimonial home. Supreme Court but however, since it was filed in the Datia, at the Datia court, the Supreme Court, in exercise of the power under Article 142 of the Constitution of India for doing complete justice, directed the complaint to be transferred to the CJM court Jabalpur. That is how the apex court has done justice to that situation. Because they have got the power under Article 142. Notwithstanding any law contrary law, the Supreme Court has got power under Article 142 of the Constitution of India to do complete justice to the parties. Thereby, the Supreme Court, noticing the lack of jurisdiction, ordered the complaint to be transferred to the CJM at Jabalpur. Manish Ratan versus State of Madhya Pradesh, 2007, Volume 1, SEC 262. The author is Justice S.B. Sinha. Similar situation, similar view was taken in Bura Ram versus State of Rajasthan also. 2008, Volume 11, SEC 103. Justice P.P. Navlekar is the author of the judgment. Now, you should also notice that we have already discussed one decision. Sunita Kumari Kashyap versus State of Bihar, AR 2011, Supreme Court 1674, corresponding to 2011, Volume 11, SEC 301, by Justice Sadashivam as the author, where it was held that continued demand for dowry made from the matrimonial home was a continuing offence. The demand for dowry continued from the matrimonial home, notwithstanding the wife leaving the matrimonial home. The demand continued. So it was held that it is a continuing offence, justifying the filing of the complaint at the place of residence of the wife. So there can be such a situation also. If the demand continues even from the matrimonial home, after the wife leaves the matrimonial home and goes to her parental home, then this decision can be pressed into service by the lawyer and by the court to hold that it being a continuing offence, the court at the place where the complainant resides can also take cognizance of the offence and try the offence. With that, we proceed to the next section, Section 179 CRPC, corresponding to Section 199 of the BNSS. Kindly read Section 199.
So, Section 199 BNSS, offence tribal where act is done or consequences ensue. When an act is an offence by reason of anything which has been done and of a consequence which has ensued, the offence may be inquired into or tried by a court within whose local jurisdiction such thing has been done or such consequence has ensued.
See, where an act is done, a consequence ensues. This is what we loosely call cause and effect. Act is done, that is the cause. What is the effect of the act? Some consequence ensues. So where the act is done, the court within whose local jurisdiction the act is done has got jurisdiction. Then the court within whose local jurisdiction the consequence ensues, that court has also jurisdiction to try the offence. Now we will discuss the questions. Question number 1.
So question number 1. Where the newspaper containing the defamatory statement against the complainant is printed at Pune in Maharashtra and published and distributed for sale at Pune, Kalyan and Mumbai and was read by the complainant at Mumbai, has the court at Mumbai got jurisdiction to try the offence?
See, clearly the section, what is the act? Act is printing and publishing of the defamatory statement in a newspaper. That is done in Pune, in Maharashtra. But that newspaper was circulated not only in Pune, Kalyan and Mumbai, and the complainant who was defamed read it from Mumbai. So that is where the consequence ensued. See? So it was held that in view of sections 178 and 179 CRPC, that is corresponding to sections 198 and 199 BNSS, to publish a libel is to make it known or to communicate it to others. To publish is to put into general circulation as distinguished from printing. It was printed in a particular place, but published, circulated in various other places. Publisher of newspaper who causes paper after printing to be circulated in ordinary manner publishes it. Publish means to bring before the public as for sale or distribution. These are the view taken by the Kerala High Court, speaking through Justice P. Shanmugam, the great judge who was from Tamil Nadu, is no more. He's a great judge. The citation is K.M. Matthew versus Abraham, 1997 to KLT 803, corresponding to ILR 1998, 1 Kerala 714. again, there's another decision. A newspaper containing a defamatory article is printed and published at one place and is circulated or sold at other places by or on behalf of the accused responsible for printing and publishing the newspaper, then that would amount to publication of the defamatory article in all such cases, and the court concerned can entertain the complaint for defamation. If the newspaper is dispatched by the printer and published to other places for being sold or circulated, the defamatory article gets published because publication is an essential ingredient of the offense. So once it is circulated, it gets published or at each of such place. The mere fact that the headquarters of a newspaper is based at a particular place or that it is printed and published at one place does not necessarily mean that there cannot be publication of the defamatory article contained in the newspaper at another place. If the defamatory imputation is made available to public at several places, then the offense is committed at every such place. This is the principle of cause and effect. P. Lankesh versus H. Shivappa, 1994, Criminal Law Journal, 3510, Karnataka High Court, by Justice S. Venkataram. Venkataram is the author of the judgment. The principle has been very beautifully stated in that decision. We pass on to question number 2.
Question number 2, sir.
Yes.
The other offences pursuant to the criminal conspiracy were committed within the jurisdiction of the court, but the criminal conspiracy was committed beyond the territorial limits of the court. Can the court try the offence of criminal conspiracy?
The criminal conspiracy was committed beyond the territorial limits of the court, but the offence for which they conspired, they hatched the conspiracy, was committed within the local limits of the court. Now the question is whether the court can try the criminal conspiracy as well. Same thing, cause and effect. It is the effect, the offences were committed within the local limits of that court pursuant to the criminal conspiracy committed elsewhere. So cause is criminal conspiracy committed elsewhere. Effect is committing the offences within the local limits of the court. So the court can try not only the offence committed pursuant to the criminal conspiracy, but also the criminal conspiracy. L.N. Mukherjee versus State of Madras, AIR 1961 Supreme Court 1601, AIR 1961 Supreme Court 1601, corresponding to 1961 to Criminal Law Journal 736. The judges are K. Subbarao and Raghubar Dayal. Kindly read the next question.
So question number 3.
Yes.
Court is having jurisdiction to try the offences committed in pursuance of the criminal conspiracy, but the offence of the criminal conspiracy was committed outside its territorial limits. Can the court also try the offence of criminal conspiracy?
I think it's a repetition.
Yes. So question number 4?
Yes. Question number, is it 4?
So
Yes.
next topic then.
Yes. Now this is the same thing. It's no offense committed pursuant to same thing. L.N. Mukherjee versus State of Madras, Subbarao and Raghubar there. I think it's a repetition of that question. I'm sorry.
Sir.
Let me make a note. Otherwise, I may repeat the mistake again. All right. Section 180. In fact, the converse is also true. In the earlier question, we saw that criminal conspiracy was committed outside the territorial limits of the court. But the offence for which the conspiracy was hatched was committed within the limits of the court. Likewise, criminal conspiracy might be committed within the local limits of the court, but the offence might have been committed elsewhere. In such case also, the cause and effect, same principle has to be borne in mind. Cause and effect, whether conspiracy was committed within the local limits, or the other offences pursuant to the conspiracy was committed within the local limits. In either case, both the courts can try the offence. That is the principle. Now we pass on to section 180 CRPC corresponding to section 200 BNS. Please
Yes.
read the section first.
So, section 200 BNSS. Place of trial where act is an offence by reason of relation to other offence.
Yes.
Where an act is an offence by reason of its relation to any other act, which is also an offence or which would be an offence if the doer were capable of committing an offence. The first mentioned offence may be inquired into or tried by a court within whose local jurisdiction either of the act was done. Either act was done.
You will know the principle better if we discuss the question. Please read that question.
So question number 1.
Yes.
A, who is in Pune, abets by instigating B at Mumbai through mobile phone to kill Z at Borivali, and pursuant to the said abatement, B kills Z. Here, by which court can A and B be tried, and as per which provision?
See, A is sitting in Pune. He calls B at Mumbai through mobile phone and instigates B to kill Z at Borivali, third place. So, Pune, Mumbai, Borivali. Borivali is the place where Z stays. So, A instigates B, A from Pune instigates B at Mumbai to kill Z at Borivali. And pursuant to the said abatement, B kills Z at Borivali. Here, by which court can A and B be tried, and as per which provision is the question? A and B can be tried at Pune in view of section 177 read with 182.1 CRPC corresponding to section 197 read with section 202.1 BNSS. That is the place from and to the phone call message was given. Message was given from Pune, so it can be tried at Pune. It was given to Mumbai, so it can be tried at Mumbai. Then A and B can also be tried at Borivali, where the murder took place pursuant to the instigation in view of section 180 CRPC corresponding to section 200 BNSS. You may read a constitutional bench ruling in case Satwant Singh versus State of Punjab, AIR 1960 Supreme Court, 266, 5 judges. Justice S.J. Imam is the author of the judgment. Of course, the facts were different there. I put this question only to understand the principle. Question number 2.
Question number 2, sir. A substandard fertilizer was illegally manufactured at Haryana and sold by an independent dealer in Punjab. Yes. Can the manufacturer be tried at Punjab, and if so, under what provision?
He can be tried at Punjab because both are offences. The first offence is manufacturing substandard fertilizer at Haryana. It led to the selling of the illegally manufactured fertilizer at Punjab. So it is a clear case falling under section 199 of BNSS. So I am sorry, section 200 BNSS, 180 CRPC. Now there is a decision also by the Punjab High Court. Haryana Cooperative Supply and Marketing Federation Limited versus State of Punjab, 1983 Criminal Law Journal, 1595. 1595. It is a division bench decision by the Punjab High Court, where the author of the judgment is Justice A.S. Baines and the other judge is B.S. Yadav. Now, this decision explains the principle of section 200 clearly. See, one offence is committed, offence of illegally manufacturing fertilizer. Substandard fertilizer is an offence committed at Haryana. Then the selling of the illegally manufactured substandard fertilizer at Punjab is the consequential offence. Therefore, They can be tried at both places. Section 200. Now question 3.
So question number 3. Although the criminal conspiracy was committed within the jurisdiction of the court, the offences pursuant to the criminal conspiracy were committed beyond its jurisdiction. Can the court try those offences?
We saw the converse in the earlier section. That is, criminal conspiracy was committed beyond the jurisdiction of the court. Here, criminal conspiracy, which is also an offence, is committed within the jurisdiction of the court. And the offences for which they hatched the conspiracy were committed outside the jurisdiction. The question is whether the court can try both the offences. Court can try both the offences because one offence led to the commission of the other offence. Therefore, the court can come clearly falling under section 200 BNSS. A court which can try an accused for an offence of criminal conspiracy is competent to try him for all offences committed in pursuance of the criminal conspiracy, irrespective of the fact that the other offences were not committed within the territorial limits of that court. R.K. Dalmia versus Delhi Administration, AIR 1962, Supreme Court, 1821, 3 judges. The author of the judgment is Raghubar Dayal, Justice Raghubar Dayal. Again, Purushottam Das Dalmia versus State of West Bengal, AIR 1961, Supreme Court, 1589. There also the author is Justice Raghubar Dayal. There are other rulings also. So I think the principle is clear. The section is also clear. Okay, we pass on to the next section. Section 181 CRPC corresponding to section 201 BNSS. Kindly read section 201.
So section 201 BNSS. Place of trial in case of certain offences. 1. Any offence of dacoity or of dacoity with murder, of belonging to a gang of dacoits, or of escaping from custody may be inquired into or tried by a court within whose local jurisdiction the offence was committed or accused person is found.
Yes.
2. Any offence of kidnapping or abduction of a person may be inquired into or tried by a court within whose local jurisdiction the person was kidnapped or abducted or was conveyed or concealed or detained.
Yes.
3rd, any offence of theft, extortion, or robbery may be inquired into or tried by a court within whose local jurisdiction the offence was committed or the stolen property, which is the subject of the offence, was possessed by any person committing it or by any person who received or retained such property knowing or having reason to believe it to be stolen property.
Yes.
4th, any offence of criminal misappropriation or of criminal breach of trust may be inquired into or tried by a court within whose local jurisdiction the offence was committed or any part of the property which is the subject of the offence was received or retained or was required to be returned or accounted for by the accused person.
Yes.
5th, any offence which includes the possession of stolen property may be inquired into or tried by a court within whose local jurisdiction the offence was committed or the stolen property was possessed by any person who received or retained it, knowing or having reason to believe it to be stolen property.
Now my first question is, I have given both section 201 BNSS and section 181 CR corresponding. Section 181 CRPC corresponds to section 201 BNSS. Do you find any physical, any somatic change, any change in the two sections? If you closely follow the sections, you will find that in subsection 1 of section 181 CRPC, any offence of being a thug and any offence of murder committed by a thug have been deleted from subsection 1 of section 201 of BNSS. BNSS has deleted the expression the thug and offense committed by a thug. This is because the sections 310 and 311 of Indian Penal Code has that is the offences committed by thug has been dropped by BNSS. That is why this change in section 201 BNSS. Now question number 2.
So question number 2. A minor girl is kidnapped from Kollam and taken to a lodge in Guruvayur.
Sorry, these are places in Kerala, which may not be very familiar to you. They were kidnapped from Kollam in Kerala, one district, taken to lodge in Guruvayur, that is another district.
Guruvayur.
Yes.
From where a demand is made through mobile phone to her father for ransom and a threat to kill the girl if the demand is not met.
Yes.
For not acceding to the demand, the girl is killed at Thrissur. The court at which place can try the offence punishable under section 364A of IPC, that is 140 BNS.
Now, if you closely examine section 140 BNS, that is section 364A of IPC, it has 3 stages. Stage 1, kidnapping or abduction. Kidnapping is of a minor from lawful guardianship. Abduction need not necessarily be of a minor, can be of a major also, adult person. Second stage is threat of death coupled with demand of money. Demand of money and threat of death coupled with demand of money. Third stage is causing death when the demand is not met. These are the 3 stages of section 364A of Indian Penal Code corresponding to section 140 of BNS. Now, all the 3 ingredients can take place at one place or at different places. Now, here it took place at different places. Therefore, courts at all the 3 places where the above ingredients took place have territorial jurisdiction to try the case. That is the principle of the section. Therefore, in this case, the court had jurisdiction. The court at which all the courts where any of these 3 things happened can try the offence. You may find the principle stated in Vishwanath Gupta versus State of Uttaranchal, 2007, volume 11 SEC 633. Judges are A.K. Mathur and Lokeshwar Singh Panta. Actually, this question falls under sections 201-2 of BNSS. Now, question number 3.
Question number 3, sir. Complaint against the father-in-law and husband, both residing at New Delhi, filed by estranged wife in the court of Patiala, within whose limits the complainant's paternal home is situated. Parental home is situated. The complaint alleges criminal breach of trust, section 406 IPC, that is section 360 BNS, in respect of dowry articles and cruelty, section 498A of IPC, that is section 85 BNS. Is the complaint at Patiala court maintainable?
See, the wife had removed herself from the matrimonial home consequent on the dowry, ill treatment, etc. Now she is in Patiala and she files a complaint of criminal under section 406 and dowry articles, in respect of dowry articles and cruelty under section 498A before the Patiala court. The question is, all these were committed in New Delhi. They were residing together in New Delhi. Then she shifted to Patiala. Now the question is whether the Patiala court can entertain the complaint and conduct inquiry and trial. Answer is yes. The dowry articles illegally appropriated by the husband and father-in-law, they are illegally appropriated. They had no business to ask for dowry because it is an offence under the Dowry Prohibition Act. So they had no business to ask for dowry. They did ask for dowry, appropriated it from the wife's parents, etc., and they have illegally appropriated the dowry, the husband and father-in-law. So they are liable because they are holding the dowry as a trustees for and on behalf of the wife, and are liable to return the same to the complainant, since it falls under the last part of section 181 4 CRPC, that is section 2014 BNSS. It was held by the Supreme Court that the complaint at Patiala is maintainable. You may refer to Kushal Kumar Gupta versus Mala Gupta, AIR 2011 Supreme Court 3805, corresponding to 2011 12 SEC, volume 12 SEC 434. With that, we pass on to the next section. Section 182 CRPC, corresponding to section 202 BNSS.
So, section 202 BNSS, offences committed by letters, etc. 1. Any offence which includes cheating may, if the deception is practiced by means of electronic communications or letters or telecommunication messages, be inquired into or tried by any court within whose local jurisdiction such electronic communications or letters or messages were sent or were received. And any offence of cheating and dishonestly inducing delivery of property may be inquired into or tried by a court within whose local jurisdiction the property was delivered by the person deceived or was received by the accused person. 2. Any offence punishable under section 82 of the Bharatiya Nyaya Sanhita 2023 may be inquired into or tried by a court within whose local jurisdiction the offence was committed or the offender last resided within his or her spouse by the first marriage, or the wife by the first marriage has taken up permanent residence after the commission of the offence.
Yes. Some is a logical extension of the cause and effect. Now, please read question number 1.
So question number 1. Pursuant to the offence of cheating and dishonestly inducing delivery of property committed by the accused from Delhi, the complainant delivered the property to the agent of the accused at Madras, where it is the court at Delhi or Madras which can try the offence.
Both courts, going by the section, both courts, where the deceit was committed or where the object of deceit is residing. Both courts can try the offence in view of section 202 CRPC, BNSS. Under section 182, that is 202 BNSS, when it is uncertain in which of the local areas an offence is committed, or where the offence is committed partly in one local area and partly in another local area, or where the offence is a continuing offence and continues to be committed in more local areas than one, or where it consists of several acts done in different local areas, it may be inquired into or tried by a court having jurisdiction over any of such local areas. This was the principle laid down by a constitution bench in Mangaldas Raghavji Ruparel versus State of Maharashtra, AR 1966 Supreme Court 128. The constitution bench spoke through Justice J.R. Madolkar. J.R. Madolkar is the author of the judgment. Now, the venue of inquiry or trial in a case when the place of embezzlement is unknown or is uncertain is primarily to be determined by the averments contained in the complaint or charge sheet. Ordinarily, the court where the charge sheet or complaint was filed has to proceed with the complaint or charge sheet unless the allegations or facts stated therein are positively disproved. This is what the Supreme Court, a 3-judge bench of the Supreme Court held in State of Madhya Pradesh versus KP Giara, year 1957 Supreme Court 196, year 1957 Supreme Court 196, 3 judges, Justice N.H. Bhagwati, Justice S.J. Imam, and Justice P. Govinda Menon. Govinda Menon being the author of the judgment. Because ordinarily, if these things are uncertain, because it is all done in secrecy. Therefore, the accused need not necessarily know the place from where it originated. Therefore, if the victim need not necessarily know the place from where it originated. Therefore, if the victim files a complaint before a particular court and alleging that it took place within the local jurisdiction of that court, it is for the accused to disprove those allegations, failing which the court has to proceed with the complaint. This is what the Constitutional Bench held in 3 judges. I'm sorry, 3 judges in State of MP versus KP Giara, AR 1957 Supreme Court 196 held. Yes, now we pass on to section 193 CRPC corresponding to section 203 of BNSS.
So, section 20.
Sorry, there's a mistake in the column 2. It should be section 203 of BNS, not CRPC.
Yes, sir. Noted, sir. So, section 203 BNSS, offense committed on journey or voyage. When an offense is committed whilst the person by or against whom or the thing in respect of which the offense is committed is in the course of performing a journey or voyage, the offense may be inquired into or tried by a court through or into whose local jurisdiction that person or thing passed in the course of that journey or voyage.
Yes.
So, question number 1.
Yes.
The victim boarded the train from Madras to Kochi. The train was bound for Trivandrum, the capital of Kerala state. When the train reached Thrissur around midnight, the dead body of the victim was found in the train's toilet. The accused, who had purchased a ticket from Salem to Trivandrum and who had boarded the train at Salem, was arrested from the railway station at Kottayam. When the train reached Kottayam, the Sessions Court, at which among the following stations from Madras to Trivandrum can try the offense of murder? The Sessions,
Sessions Court at
the Sessions Court at Madras, Salem, Coimbatore, Palakkad, Thrissur, Kochi, Kottayam, Kollam, Trivandrum.
Now, these are the 9 stations on the way, starting from Madras to Tirunelveli. There are 9 stations. Now, the question is, the Sessions Courts at which all stations can try the offense? Applying this section, section 203 of BNSS, corresponding to section 183 of CRPC, which all courts can try, the Sessions Courts at which all stations can try the offense? Can the Sessions Courts at all the stations try the offense? Now the question, if you carefully read the section, you will find that the accused, the answer is the Sessions Courts at those stations through which either the victim or the accused undertook the journey, performed their journey, can try the offense. Now the victim boarded the train from Madras, starting station, Madras, and travelled till Thrissur only, where his dead body was found. The accused boarded the train midway from Salem and travelled up to Kottayam, beyond Thrissur and Ernakulam, Thrissur and Kochi. Therefore, the accused boarded the train he had boarded the train at Salem and travelled up to Kottayam. So, serial numbers 8 and 9, that is Kollam and Tirunelveli, which are beyond Kottayam, those stations, the courts at those stations have no jurisdiction. But all the other stations, Madras, because the victim boarded the train from Madras, he passed through Madras, Salem, Coimbatore, Palakkad, Thrissur. 5 of the stations, his body was found at Thrissur. Now, take the case of the accused. Accused boarded the train from the second station, Salem. He was there in the train from Salem, Coimbatore, Palakkad, Thrissur, Kochi, and Kottayam, up to Kottayam. Oh, he had committed the murder at Thrissur and traveled up to Kottayam, from where he was arrested. So, all the stations from Madras to Kottayam, where either the victim or the accused traveled, have got jurisdiction. I suppose you got the principle. Got the principle of the section. This is the section. Therefore, this one single instance will prove the section. Yes. We pass on to the next section, section 184 TRP, corresponding to section 204 of BNSS.
Yes. So section 204 BNSS, place of trial for offences triable together, where A, the offences committed by any person are such that he may be charged with and tried at one trial for each such offence by virtue of provisions of section 242, section 243 or section 244, or the offences B, or the offences or offences committed by several persons are such that they may be charged with and tried together by virtue of provisions of section 246. The offences may be inquired into or tried by any court competent to inquire into or try any of the offences.
See, you can better understand this section only if you are thorough with the chapter on framing of charge. Section 184(1)(a), 184(a) CRPC, that is corresponding to section 204(a) BNSS, deals with trial in cases of joinder of charges, and section 184(b) CRPC, corresponding to section 204(b) BNSS, deals with joinder of offenders. One is clause 8 deals with joinder of charges, offences, and clause B deals with joinder of offenders, plurality of accused. It's only when you are thorough with the. In fact, I had given a few lectures on framing of charge, but it was not completed. We will do that in the course of time. So, where there can be joinder of charges with regard to offences under sections 219, 220 and 221 CRPC, corresponding to sections 242, 243 and 244 BNSS, or where there can be joinder of charges with regard to offenders under section 223 CRPC, corresponding to 246 BNSS, then the offences may be tried by any court competent to try any of the offences. Now we will discuss the examples. Example for clause A falling under section 219 CRP. 219 is corresponding to 242 BNSS. Under section 219 CRPC, that is 242 BNSS, if 3 offences of the same kind, because BNSS has added the number from 3 to 5, barring that there is no difference. And if 3 offences or 5 offences according to 242 BNSS, 5 offences of the same kind, punishable with the same amount of punishment, were committed within 12 months, then they can be tried together. Those offences can be tried together. Offences. Here the stress is on the offences. Of course, 242 BNSS has increased the number of offences from 3 to 5, whereas under section 219 CRPC, it was 3 offences. Here it is 5 offences committed within 12 months. Then they can be tried together. Here the stress, emphasis is on the section, on the charge, on the offence. Then, supposing the 3 offences were committed, one at Kochi in the state of Kerala, another at Coimbatore in the state of Tamil Nadu, and the other at Bangalore in the state of Karnataka, then all the 3 offences can be tried by any of the courts at Kochi, Coimbatore or Bangalore. This is the principle. Then yet another example for clause A. falling under section 221 CRP, that is 243, section 243(1) of BNSS, where 5 offences are committed by the sole accused as part of the same transaction. Occurrence is same. 5 offences committed. Here also the emphasis is on offences. 5 offences committed by the sole accused as part of the same transaction. Then he can be charged with and tried for every such offence by virtue of section 220 clause 1 of CRPC, that is corresponding to section 243 clause 1 of BNSS. Clause A of section 18 of section 204 BNSS permits trial of such a person by any court competent to try any of the aforesaid 5 offences. This is the principle of clause A, which falls with regard to cases falling under section 243(1) of BNSS. Now we will consider yet another example for clause A falling under section 221(1), section 221(1) CRPC corresponding to 244(1) BNSS, where an accused is charged with a particular offence, but the evidence discloses that he committed a different offence for which he could have been charged under section 244(1) BNSS, then the case falls under sections 244(2) BNSS. In such a case, section 204A BNSS permits trial of such different offence by any court competent to try such offence. So, charge is for a particular offence, but what is disclosed by the evidence is a different offence for which also he could have been charged. Then that court can try the difference of, try and convict the accused for the different offence also. Then we come to an example for clause B falling under section 223. In all the earlier examples, it was offence centric, rather it was, the stress was on offences. Now clause B of section 246 BNSS is with regard to offenders. If 2 or more persons committed 1 or more offences for which they could be charged under section 223 CRPC corresponding to section 246 BNSS, then the offences can be tried by any court competent to try any of those offences. Here the stress is on the plurality of offenders. Now let us examine a question under section 204 BNSS. Please read question number 1.
So question number 1. A minor girl was kidnapped, section 366 IPC, that is section 87 BNS, from Chennai and taken to Avadi, 25 kilometers away, and raped, section 376 IPC, section 64-65 BNS at Avadi, whether the court at Madras or Avadi can try the offences.
Here the kidnapping was done at Chennai and the girl was taken to Avadi from where she was raped. Both by virtue of section 204 BNSS, both the courts can try the offences since they were committed as forming part of the same transaction within the meaning of section 220 CRPC. In view of section 184A CRPC, that is 204A BNSS. The case falls under section 204A of BNSS. You may refer to one decision by a division bench of the Karnataka High Court, State of Karnataka versus M. Balakrishna, 1980 Criminal Law Journal, 1145. 1980 Criminal Law Journal, 1145. The judges are S.R. Rengagowda and M. Nagappa. Justice M. Nagappa being the author of the judgment. With that, we pass on to section 185. That is section 205 of BNSS.
So section 205 BNSS.
Yes.
Power to order cases to be tried in different sessions divisions.
Yes.
Notwithstanding anything contained in the preceding provisions of this chapter, the state government may direct that any case or class of cases committed for trial in any district may be tried by any sessions division, provided that such direction is not repugnant to any direction previously issued by the High Court or the Supreme Court under the Constitution or under this Sahita or any other law for the time being in force.
Yes. Now see, the state government is given the authority to direct that any case or class of cases committed for trial in a particular district may be tried in any sessions division, any other sessions division. But this direction, this power of giving direction to the state government is always subject to any direction already issued by the High Court concerned or by the Supreme Court. This is what this section says. It doesn't require any case law. In fact, there is no case law also, but the principle is clear. State government is given the power to give a direction to that any case, class of cases may be tried in a particular sessions division. But the state government cannot issue a direction contrary to an earlier direction issued either by the High Court or by the Supreme Court. This is what the section says. Now we pass on to the next section, section 186 CRPC, that is section 206 of BNSS.
The section 206 BNSS, yes. High Court to decide in case of doubt, district where inquiry or trial shall take place.
Yes.
Where two or more courts have taken cognizance of the same offence and a question arises as to which of them ought to inquire into or try that offence, the question shall be decided A, if the courts are subordinate to the same High Court by that High Court. B, if the courts are not subordinate to the same High Court by the High Court within the local limits of whose appellate criminal jurisdiction the proceedings were first commenced, and thereupon all other proceedings in respect of that offence shall be discontinued.
See, until now, we were discussing the various courts which can try offences if they were committed part of the same transaction, various offences, etc. Now we saw that criminal conspiracy committed within the local limits of one court, and the other offences pursuant to the conspiracy committed within the jurisdiction of some other court. Both these courts can try the offence. But supposing two courts, there are plurality of offenders and plurality of victims, and more than one court takes cognizance of the same occurrence is only same occurrence, then which court has to continue with the trial? So this is that section which authorizes the High Court to direct as to which court shall continue, in which once the High Court directs, then the court which direct that, supposing court, there are three courts, court A, B and C, and all the three courts have taken cognizance of the offence on the complaint or police report of different persons. Now, the case can be tried only by one court. Therefore, High Court will direct that court B shall continue with the trial. In which case, the court A and court C shall discontinue the proceedings, and the court B shall try all the offences. That is the principle here. Now, there is one confusion. Supposing the two courts are within the limits of two High Courts, not under the same High Court. Supposing the two places are one court is within the jurisdiction of the Bombay High Court, and the other court is within the jurisdiction of the Karnataka High Court. Then which court has to decide? There the answer is, which is the court, which is the proceeding, which proceeding started first, and supposing the proceeding at Karnataka, at Bombay was started first, and the appellate and the proceeding at the Karnataka was started subsequently, and then we have to decide which is the appellate High Court, which is the jurisdiction of the appellate High Court, that is at Bombay. So if the first case was initiated at Bombay, and the Court of Appeal is at the Bombay High Court, then that Bombay High Court will decide. Karnataka High Court will have no jurisdiction to decide the question. That is a case where the two courts under two different High Courts have taken cognizance of the same offence. But in the other case, where two courts within the same High Court, within the limits of the same High Court have taken cognizance of offence, the same High Court can issue direction. But if those two courts are within the local limits of two different High Courts, then the principle is B. The court are not supported the High Court within the local limits of whose appellate criminal jurisdiction the proceedings were first commenced, that High Court will decide. That is the principle. Now we pass on to question number, the section 186, 206.
So question number 1.
Yes.
What are the requirements of attracting section 186 CRPC, that is section 206 BNSS?
The cases instituted in different courts must be in respect of the same offence arising of the same occurrence. Same offence would mean the acts and omissions which constitute the offence are one and the same. Example, section 184 clause A of CRPC, that is section 204A of BNSS, same offence. Second is the transaction and the party should be same. In other words, the persons implicated as accused in the different cases should be the same. It falls under section 184B of CRPC, that is 204B of BNSS. These principles were laid down by the Supreme Court in State of Rajasthan versus Bhagwan Das Agrawal, 2013, 16 SEC 574. 2013, 16 SEC 574. Justice C.K. Prasad and M.V. Iqbal. Justice M.V. Iqbal is the author of the judgment. Now we pass on to section 187 CRPC, corresponding to section 207 BNSS.
So section 207 BNSS. Power to issue summons or warrant for offence committed beyond local jurisdiction. 1. When a magistrate of the first class sees reason to believe that any person within his local jurisdiction has committed outside such jurisdiction, whether within or outside India, an offence which cannot, under the provisions of section 197 to 205, both inclusive, or any other law for the time being in force, be inquired into or tried within such jurisdiction, but is under any law for the time being in force tribal in India, such magistrate may inquire into the offence as if it had been committed within such local jurisdiction and compel such person in the manner herein before provided to appear before him and send such person to the magistrate having jurisdiction to inquire into or try such offence. Or if such offence is not punishable with death or imprisonment for life, and such person is ready and willing to give bail to the satisfaction of the magistrate acting under this section, take a bond or bail bond for his appearance before the magistrate having such jurisdiction. 2. When there are more magistrates than one having such jurisdiction and the magistrate acting under this section cannot satisfy himself as to the magistrate to or before whom such person should be sent or bound to appear, the case shall be reported for the orders of the High Court.
Now, reading the section, it may appear to be a bit complicated, but actually it is not so complicated. I will explain that while giving the answer to question number 1. Please read question number 1.
Question number 1. What is the essence of section 187 CRPC, that is 207 BNSS?
Supposing A is the accused. A, the accused who is found within the local limits of a magistrate at Kochi in the state of Kerala. A is found within the local limits of the magistrate at Kochi in state of Kerala. He is seen to have committed an offence at Bangalore in the state of Karnataka. A is there in Kochi, in Cochin, in Kerala, but he is seen to have committed an offence in Bangalore, which is in Karnataka. And if the magistrate at Kochi does not have jurisdiction to try A under any of the provisions of sections 197 to 205 BNS. We have seen which is the court which can try the offense, try the offender. Now, A, who is found within the local limits of the Cochin magistrate, Cochin magistrate does not have jurisdiction to try him because offense was committed at Bangalore in Karnataka. So the Cochin magistrate does not have the jurisdiction to try A, but A is found in the local limits of the Cochin magistrate. Then what should be done? Then the magistrate at Kochi can conduct an inquiry for the limited purpose of securing the presence of A before him, and then send him to the magistrate at Bangalore, having jurisdiction to try him or commit him for trial. If there are more magistrates having jurisdiction to try A, then the magistrate has to report the matter for the orders of the High Court. This is the principle. I suppose you got the principle. The accused is found within the local limits of a particular magistrate. Now, that magistrate does not have the power to try him because he had committed the offense elsewhere, outside the local limits. In the particular case, he committed the offense at Bangalore, whereas he is found in the local limits of Kochi, Kerala. Therefore, the Cochin magistrate cannot try him. But Cochin magistrate can conduct an inquiry, a limited inquiry, for the purpose of securing his presence before him. The magistrate may secure his presence before him and then send him to the Karnataka court for trial. In the meanwhile, he can release him on bond and ask him on condition that he will appear before the Karnataka court. This is the principle of section 187 CRPC corresponding to section 207 BNSS. But unfortunately, there are in Kerala and Tamil Nadu, I know only that. I don't know whether it is happening in other states also. This power under section 187 CRPC was being misused, and an accused person, after evading his arrest by the police, surrenders before a convenient magistrate and gets himself remanded to judicial custody. This section used to be wrongly invoked by the magistrates for remanding the accused to custody. This section does not have any application to such situations. A person after committing an offense elsewhere will surrender before another magistrate who may be a lenient magistrate, convenient magistrate. That is why I use the expression convenient magistrate, a lenient magistrate, and gets him remanded to judicial custody. That magistrate does not have the power to remand him. Therefore, this device was being misused. This section was being misused in Kerala and Tamil Nadu. I don't know other states, and it was not found favor by the High Court, because this is not the provision for surrendering for an accused who committed an offense elsewhere to surrender before a magistrate and get himself remanded. Thereby, he is avoiding an arrest by the police. He is avoiding an investigation involving him by the police, etc. Therefore, this is not the provision for such thing. This is a provision enabling a magistrate to secure the presence of a person who has committed an offense elsewhere and then send him to that court for the purpose of trial. This is the purpose of this section. I suppose you have understood the position. Is that clear?
Absolutely, sir.
Oh, okay. Thank you. Now we pass on to the next section. Section 188 CRP, responding to section 208 of BNSS.
So section 208 BNSS, offense committed outside India. When an offense is committed outside India, A, by a citizen of India, whether on the high seas or elsewhere, or B, by a person not being such citizen, on any ship or aircraft registered in India, he may be dealt with in respect of such offense as if it had been committed at any place within India at which he may be found or where the offense is registered in India, provided that, notwithstanding anything in any of the preceding sections of this chapter, no such offense shall be inquired into or tried in India except with the previous sanction of the central government.
Yes. See the principle. Principle is an Indian citizen committing an offense abroad. An Indian citizen committing an offense either on the high seas or elsewhere out of India. Then a non-citizen committing an offense in a ship or aircraft registered in India. A ship of aircraft registered in India, maybe in Japan or maybe in China, but and a non-citizen, a person who is not a citizen of India, commits an offense in a ship or aircraft registered in India. There is a logical and territorial extension of the Indian of India to that ship or aircraft. That ship or aircraft is considered to be a logical extension of India itself, territory of India itself. And if an offense is committed by a foreigner on an Indian ship or an Indian aircraft, this section is attractive. Likewise, if a citizen of India commits an offense outside India or on the high seas, this section is attractive. But then, no inquiry or trial shall be committed, and he shall be tried in any place where he is found in India. Such a person can be tried in India or where the offense is registered in India. He can be tried at any place where he has been found in India or where the offense has been registered in India. But the proviso says no such offense shall be inquired into or tried in India except with the previous sanction of the central government. Without the previous sanction of the central government, such a person shall not be, an inquiry or trial shall not be conducted in respect of such a person who committed an offense either abroad or in a ship or aircraft registered in India. Now we discuss the questions. Question number 1.
So question number 1. Alleging that the complainant, a native of Gujarat, and her husband were residing together at Kuwait, where she was ill-treated by her husband at the instigation of her mother-in-law, Fatima Bibi Ahmed Patel, a citizen of Mauritius. A complaint was filed against the mother-in-law for the offence under Section 498A IPC, that is Section 85 BNS, before the CJM court at Gujarat. Can the CJM conduct an inquiry or trial without the previous sanction of the central government under the proviso to Section 188 CRPC, that is 208 BNSS?
Question is whether Section 1, the case falls under Section 188 CRPC. See, the offence was committed at the instigation of the mother-in-law, who is a Mauritius citizen. He is neither an Indian citizen nor a citizen nor a non-citizen residing in a ship or aircraft registered in India. Therefore, the mother-in-law is a total stranger residing outside India. So this is not a case falling under Section 188 CRPC. Section 188 CRPC has the extraterritorial jurisdiction or operation of the case of a foreign citizen who has not committed any offense in any ship or aircraft registered in India within the meaning of Section 188B. Therefore, this lady is she cannot be prosecuted for any offense in India, any offense under the Indian Penal Code or under the Indian Penal Code. Therefore, the Supreme Court held that she, being a foreigner and who allegedly committed an offense outside India, not in an Indian in a ship registered in India or in an aircraft registered in India. She is a total foreigner committing an offense in foreign land. She cannot be brought under the scope of Section 188 CRPC or 208 BNSS. So the Supreme Court held that nothing can be done because the case does not fall under Section 188 itself. Fatima Bibi Ahmad Patel versus State of Gujarat. AR 2008 Supreme Court 2392, corresponding to 2008, Volume 6, SCC 789. Justice S.B. Sinha is the author of the judgment. So section, please clearly understand the section. And Indian citizen committing an offence abroad or on the high seas, which is considered to be outside India, or a non-citizen committing an offence in a ship or aircraft registered in India. In these two cases alone, Section 188 is attractive. This is a case where she is a foreign citizen and committing and instigating an offence while in foreign territory. 180 has no application at all. Therefore, the case was dropped by the Supreme Court. Question number 2.
Question number 2, sir. A Dubai-based bank was cheated and defrauded by an Indian who thereafter fled to India from Dubai. A complaint was filed by the victim bank before a magistrate at Madras. The magistrate issued processes and non-bailable warrants against the accused. The accused challenged the orders of the magistrate and seek quashing of the complaint, alleging that he is doing business in Gujarat and Madras is not the place where he may be found within the meaning of Section 188 CRPC, that is Section 208 BNSS. Is he not entitled to succeed?
No, he cannot succeed. Victim can complain about the offence before any competent court in India which the complainant may find convenient. The expression at the place at which he may be found in India occurring in Section 188 has to be interpreted by holding that finding of the accused under Section 188 has to be by the court and not by the police or by the complainant. It is not the complainant or the police who finds him in India. It is the court which has to find him in India. And the section was interpreted to mean that it is for the court to find whether he was found in India or not for the complainant or the police to find that he was found in India. Om Hemeranjini versus State of UP, AIR 2005 Supreme Court 392. AIR 2005 Supreme Court 392. Justice Y.K. Sabharwal is the author of the judgment. Of course, the facts are different. Now, for the applicability of Section 188 CRPC corresponding to Section 208 BNSS, it is immaterial whether the person committing an offence outside India comes to India voluntarily or in answer to summons or under illegal arrest. Supposing he is found in India pursuant to an illegal arrest, he has been illegally arrested and brought to India, or he voluntarily comes to India in answer to summons, he can be held to be found in India. Mubarak Ali versus State of Bombay, AIR 1957 Supreme Court 857. AIR 1957 Supreme Court 857, 3-judge bench. The author of the judgment is Justice Jagannath Das. Justice Jagannath Das. The other judges were S.J. Imam and P. Govinda Menon. Now, question number 3. Please read.
Question number 3, sir. Part of an offence is committed in India and the remaining part is committed in Dubai. Is it permissible to conduct an inquiry or trial without the previous sanction of central government as enjoined by the proviso to Section 188 CRPC, that is 208 BNSS?
Is it not a case falling under Section 188 CRPC? That is 208 BNSS. Offences committed in India and Dubai. This is not an offence committed outside India. This is an offence committed both in India and abroad. Therefore, 188 is not attracted at all. For attracting Section 188, that is 208 BNSS, the offence should have been wholly committed abroad, outside India. But here it is partly committed in India also. Is it not? Therefore, the section is not attracted. You may refer to Ajay Agarwal versus Union of India, AIR 1993 Supreme Court 1637. Justice K. Ramaswamy and R.M. Sahai both have given independent judgments. Again, Tota Venkateshwarlu versus State of Andhra Pradesh, AIR 2011 Supreme Court, 2900, 3 judges, Altamas Kabir, Siriak Joseph, and SS Nijar. But then, yes. Question number 4. Please read question number 4.
Question number 4, sir. Previous sanction of the central government under the proviso to section 188 CRPC, that is 208 BNSS, is not a condition precedent for taking cognizance of the offence, and such sanction can be obtained before the commencement of trial. Is not the above proposition of law correct?
Now see the wording of section 180, the proviso, wording of the proviso, provided that notwithstanding anything in any of the preceding sections of this chapter, no such offence shall be inquired into or tried. So no inquiry or trial shall be conducted without the previous sanction of the central government. Now I am giving a proposition. Previous sanction of the central government under the proviso to section 208 BNSS is not a condition precedent for taking cognizance of the offence, and such sanction can be obtained before the commencement of trial. Is not the above proposition of law correct? See, taking cognizance of an offence is part of the inquiry. Taking cognizance of the offence is part of the inquiry. Proviso to section 208 BNSS says no inquiry or trial without the previous sanction of the government. Now, if previous sanction of the government has not been obtained, there cannot be any inquiry or trial. Now, taking cognizance is part of an inquiry. Now, the proposition is it can be taken, the sanction can be obtained before the commencement of trial. When does the trial commence? We have already seen. When does the trial commence? After taking cognizance, process is issued to the accused, accused appears, and he is supplied with all the prosecution records, and then a charge is framed, and his plea is taken, and he pleads not guilty. It is only when he pleads not guilty that the trial starts. We have seen the beautiful judgment of Justice Sarkaria, 3-judge bench, AR 1979 Supreme Court, page 94. Ratilal Banji Mithani versus State of Maharashtra, AR 1979 Supreme Court, page 94. There it is beautifully stated that if after taking his plea, he pleads not guilty, then only the trial starts. This is all. Therefore, until then it is inquiry. So there cannot be any inquiry also without the previous sanction of the government. Now it is here that the earlier rulings which I mentioned to you have committed the mistake. In Ajay Agarwal versus Union of India, AIR 1993 Supreme Court, 1637, and in Tota Venkateshwarlu versus State of Andhra Pradesh, AIR 2011 Supreme Court, 2900, 3 judges bench. In both the judgments, they were clearly right. The benches were correct, exactly correct in saying that since the offences were not committed wholly abroad, part of the offence was committed in India, section 188 has no application. Both the courts, both the judgments have correctly laid down the proposition. The proposition has been correctly laid down that since part of the offence is committed in India, section 188 is not abstracted. But there is a further statement in both the judgments. That statement has created confusion. In both the judgments, there is a further statement which was really unnecessary because section 188 is not attracted. But the judges say even if section 188 does not apply, it would be even if section 188 applies, the judges say even if section 188 applies, it is enough that the permission of the central government is obtained before the commencement of trial. That means inquiry can be conducted. That is the mistake committed by both the verdicts. First of all, they held that, very correctly held that Section 188 has no application in the case because the offences were not solely committed abroad. Part of the offence was committed in India. So 188 is out of bounds. It has no application at all. The further observation was unnecessary and it is wrong also, according to me, with due respect. They say that even if Section 188 is attracted, it is enough if the permit of the central government is obtained before the commencement of trial. What about the taking cognizance? The act of taking cognizance is inquiry, which is also not permitted by the proviso. Therefore, to that extent, these two rulings are, according to me, in my humble opinion, not correct. Therefore, that is why I gave you that observation in the question. That observation is not correct. But the verdicts are correct because Section 188 was not attracted in this case. But unnecessarily an observation is made. Even if Section 188 is attracted, of the permission of the central government can be obtained before the commencement of trial, which is after inquiry. No inquiry or trial is what the proviso says. To that extent, the observations are, with due respect, not correct. I gave this illustration only to highlight this aspect of the matter. Now we pass on to the last section, where there is no case law. It is only a procedure in a case where Section 188 is applicable. Please read Section 209 BNSS.
So Section 209 BNSS. Receipt of evidence relating to offences committed outside India.
Yes.
When any offence alleged to have been committed in a territory outside India is being inquired into or tried under the provisions of Section 208, the central government may, if it thinks fit, direct that copies of deposition made or exhibits produced, either in physical form or in electronic form, before a judicial officer in or for that territory or before a diplomatic or consular representative of India in or for that territory shall be received as evidence by the court holding such inquiry or trial in any case in which such court might issue a commission for taking evidence as to the matters to which such depositions or exhibits relate.
This is a procedure where an offence has been committed outside India, falling under Section 208 of CRPC, of BNS, 188 of CRPC. Therefore, it's only procedure. With that, we have concluded the discussion on inquiries and trials before court, the jurisdiction of the criminal court for conducting inquiries and trials. We saw what is an inquiry, when does it commence, when does it end. We saw what is a trial, when does it commence. Of course, we also saw the wrong observations made even by a constitutional bench as to the commencement of trial. Of course, it is really, they follow the constitutional bench has really followed Rasilal Banji Mitani, which clearly says that trial commences only when the accused pleads not guilty. But that fine distinction has not been noted by the constitutional bench. Notwithstanding that they are all great judges. I don't want to criticize any judge because they are all great judges. Any person may commit mistakes unknowingly. They are all out of oversight. Even I have committed mistakes. Nobody is above. To commit to err is human and to forgive is divine. We are not even forgiving that. We are only noticing that a particular aspect of a judgment does not lay down the law correctly. That's all. We are only noticing that. Barring that, they are all great judges. They don't deliberately make any mistakes at all. Therefore, with that, we have come to an end. Now, what remains is not in the present context. I had given a promise to LiveLaw that I will give a lecture on confessions. That is starting with sections 24 to 30 of the Evidence Act, Indian Evidence Act. That probably I may take from Ireland. I'm traveling to Ireland in 6th June to my daughter's place. I will be there for a month. If possible, I will try to address you from Ireland. With that, we can conclude.
It will be our pleasure, sir. So with that, we bring today's enlightening session to a close. A heartfelt thank you to all the audience for being such a vibrant and inquisitive audience. Most importantly, sir, we express our deepest gratitude to Justice V. Ramkumar, sir, for not just walking us through the statutory framework and judicial precedents, but also for highlighting the whys and what's behind these concepts. So, your clarity and generosity in sharing your wisdom continues to inspire us all. I hope you all enjoyed this format of question and answers. Thank you so much, sir, for your time and knowledge. Until then, until next time, keep reading, keep questioning. And if you have any doubts, please put it in the comment section. We will surely answer them all. Have a wonderful evening ahead. Thank you so much, sir.
You're welcome. Good night.
Good night, sir.